Morning. Please be seated. We are here for oral argument on Tyler Strang versus Malay / Hernandez. It's our number CV-25-0233. A couple things before we get started. Each side has 20 minutes, and let's see, this is the great case, yeah. Yes, okay. This is the case where Ms. Malay is aligned with Strang, correct? On the same side, on the same position. Yes, so we have, even though the caption has you opposing, you're not going to arrange for this beforehand, so I just want to make sure you all are clear that you're on the same side, so you split the same time the position, whichever side. Sorry, I'm mixing up my sides. So yes, so just make sure we do that. And then you keep whatever time you wish for rebuttal. You just have to keep your time yourself. So, sorry, I'm squeaking you out looking this way, or it's that way. Anyway, please begin.
Good morning, Your Honors, and may it please the Court. My name is Alex Salin, and I represent the petitioner in this matter, Tyler Strang, the biological father. I will be splitting my time today with Mr. Murray, who represents the mother in this case. We've agreed that I'll give Mr. Murray about 5 minutes, and I will strive to save some time for rebuttal.
I just recently had a birthday, so my ears are getting worse. Do you mind speaking up?
Of course, Your Honor.
Thank you.
You can just pull that microphone closer. We've noticed that it doesn't really pick up unless it's like right there.
Thank you, Your Honors. The fundamental right to parent your child is one of the oldest recognized constitutional rights in this country, as recognized by the Supreme Court in cases like Troxel and Santosky. To comply with due process in light of that constitutional right, a parent is entitled to receive notice and the opportunity to be heard before the parental right can be taken away.
Doesn't that occur, counsel, when the parentage has been established? And in this case, it hadn't been established as to your client.
The problem here, Your Honor, is that he was not provided notice. Mr. Strang had no idea this acknowledgement was signed. He was told this wasn't his child, that it was impossible to be his child. And mother believed that Mr. Hernandez at the time was the child's father. The acknowledgement was signed at the hospital a couple days after the birth of the child. Mr. Strang had no idea that this acknowledgement was signed or filed with the department. He only learned years later that the acknowledgement had been filed.
Counsel, may I ask you a question? Because that acknowledgement of paternity process within that statute, in Roger S., the Court of Appeals laid out the source for that being federal law in order for the state to be able to participate in a federal program. I didn't see your briefing address the validity of that federal requirement. If our statute is in alignment with it, and as Roger S. lays out, that was a requirement for the state to abide by, is it your real rub with the federal law, which I didn't see challenged here?
Your Honor, I don't believe that the court has to take our position as correct, find that the federal law shouldn't be applied here. The federal law simply requires that to contest an acknowledgement of paternity, and it's 42 section 666. It requires to contest an acknowledgement of paternity that it may only be challenged on the basis of fraud, duress, or material mistake of fact. It has no time limitation that causes the real problem in this case. And that's what the Brumman court recognized. While not quoting the federal statute in Brumman, the real problem is the time limitation that the Roger S. court and the Johnson court imposed on biological fathers who have no notice that this acknowledgement was ever signed or essentially entered as a judgment against them.
How long after he took the genetic test did he wait until file his action?
So there were two genetic tests in this case, Your Honor. The first was done in November of 2023. After that point, Mr. Strang testified at the hearing in this case on the motion to dismiss that he spoke with mother. They were deciding what to do about all of this, and that mother was going to move forward in filing a petition to establish. In that petition, she stated that Hernandez was not the father of the child and asked that he not be awarded parenting time. Subsequently, there was another biological DNA test done in June of 2024. Soon after that, Strang did file his petition in the already pending action to establish his rights. So it was more than
6 months, though, that, I guess at some point there has to be stability for the child's life, and I think that that's what those timeframes are set out for. And I'm sympathetic to the biological father that doesn't know that it's his child, but once he took the test, and the rule is 6 months, that's plenty of time. I mean, how would you recommend that we approach that? And bearing in mind that we're also concerned with future cases, that can somebody come back 5 years later, 10 years later? I mean, there has to be some type of limit, and it seemed like the rule set it at 6 months.
Of course, Your Honor. And the problem is that the rule is based on when the judgment is entered, which in this case, he had no idea a judgment had been entered. And so I think there can still be limitations on this right. The idea of equitable estoppel, which this court applied in McLaughlin v. Jones, is one of those ways in which if a father finds out, I'm the biological father, he says, I don't want anything to do with this, sits on his hands for years. Another man steps up, he's the legal father of this child. Under 25-814, I think the court could say, you're equitably estopped at this point from establishing parenthood. This other man is the father of this child. And you can find that in the language of 814C, where it requires the court, when two presumptions of paternity apply, that the court has to look at the facts and decide which presumption should be applied in that particular case based on policy and logic.
Could latches also operate in that context?
I believe it could, Your Honor. And so I think that is adequate protections for a child. For example, if a man was the legal father of a child for 16 years, and suddenly the biological father takes an interest after knowing that entire time that he was the biological father, I think the court would have the discretion in that circumstance to say, in this case, policy and logic demand that the legal father should be considered the father of this child.
Since you mentioned 814C, what's the significance of the final sentence in 814C? A court decree establishing paternity of the child by another man rebuts the presumption.
Yes, and the Johnson court did address that language about the court decree. And the Johnson court stated that because an acknowledgement of paternity is treated like a judgment, that just like a judgment, it would be treated as a court decree under 814C. However, I believe that's a misinterpretation because the terms used are different. A acknowledgement of paternity is treated like a judgment. It is not a court decree. For example, in Rule 45 of our family law rules, it delineates out decree, judgment, or order multiple times, and you can see that throughout the rules. So these are distinct, different orders in a case.
Where are these terms defined? Are they defined in statute?
I don't know that there is a statutory definition. However, I do believe because the language is different between the two statutes that we do need to treat them differently.
What's the definition of a decree? For example, in Black's Law Dictionary.
I don't know what Black's Law has defined a decree as.
It defines it as an order or judgment by a court definitively resolving an issue as to parties in a case.
I believe because of the language of 814C that there is still a problem in reading acknowledgement paternity as a court decree. A court decree, I believe the plain language would presume that the court is entering a decree, versus if you look to 812, it states that a voluntary acknowledgement of paternity made pursuant to this section is a determination of paternity and has the same force and effect as a superior court judgment. It's not a court decree as defined by 812A. And so I believe we do need to treat those language differences as two different items.
Well, the acknowledgement can be also filed with the Department of Economic Security or the Department of Health Services and treated as a judgment. That's the way I read 812A. Is that correct?
Yes, it can be filed with the department, and I believe it was in this case, or it can be filed with the court. When that occurs, I just want to clarify, when that occurs, is there any court interaction other than treatment as a judgment? Does the court then go ahead and enter a decree or a judgment or something that reflects the finality of the acknowledgement? No, there is no further action by the court. Until a petition is filed in the court, the acknowledgement is treated as a judgment, but there's no case filing, there's no case number.
So, counsel, what is the constitutionally required notice that you claim is missing?
And I believe this court's prior cases recognize that there has to be some form of notice, whether there's publication, whether in Arizona, Strang could not even obtain a copy of the acknowledgement of paternity. Even if he ordered it through a public records request, he has no ability to obtain this document.
And who is supposed to give that notice? Who's constitutionally required to give that notice?
I believe, whether the parties tell him, hey, you might be the father, we've signed an acknowledgement, I think that would be actual notice. If the acknowledgements of paternity, some states have them publicly available, that you can obtain one from the state. If those were somehow available, that might change the consideration.
So do you propose that the rule be that the persons who sign the acknowledgement of paternity issue some public notice in cases where there's not a biological match between the father and the child?
I don't know that that's statutorily required.
It isn't.
No. And so I think it depends on the specific facts of each case, but there does have to be some form of notice.
Well, and I think the fact is, as Justice Cruz is indicating, there is no requirement. And that's what is the essence of your due process claim.
Yes,
right?
Your Honor. Because without any form of notice, it's a judgment entered against somebody who is not a party to the judgment. In any other circumstance, a judgment can't be entered against you without some form of notice and due process and the opportunity to be heard. And so here we're taking a fundamental right to parent away from somebody who, once Strang did find out, he reached out to mother. He started working towards trying to establish parental rights to this child.
So what is the nature of that right here? The Lair case suggests that there is some sort of right, but it's not on the same status as someone who is known from the get-go to be the parent.
Well, and I think this court discussed that recently in Ray N.N., talking about their putative fathers and potential fathers, and that potential fathers and putative fathers are both entitled to some protections under the Constitution. And if they sit on their hands and do nothing and don't want to be involved in the child's life, then they generally lose those protections. Here, once Strang learned that he was a potential father, he then took the DNA test and learned he was the biological father. He took steps to become involved in this child's life. And these are the types of cases where we want to protect those potential fathers.
Are you arguing that, the way at least I read the rule, and if you made a Rule 85 motion under C1, 2, and 3, you have the 6 months to make this claim. Clearly that didn't happen. Are you arguing that the rule in conjunction with the statute should be interpreted differently, or are you agreeing that what I just said is what it says and that it's being applied unconstitutionally to your client because of the lack of notice?
So I believe Brumman addressed this properly in that Rule 85, which the prior version of the rule had the time limitations, all of the potential avenues for relief, and the independent action language and fraud upon the court language under subsection C. It has been delineated since then, but the independent action doctrine that's recognized in now D1 of the rule was under subsection C. I believe the Brumman court was correct in interpreting that allows a biological father who had no notice that this judgment was entered to come in and file a petition to establish without being bound by the time limitations of Rule 85.
And you discern all of that from a subpart of the rule that's in tension with the language of the statute, which limits the basis to challenge, to mistake, duress?
Yes, I believe so, Your Honor, because that's the only way we can read this within the confines of due process and Strang's constitutional right to parent. And the Brumman court goes through how reading the statute any other way would require absurd results, where even at 6 months and a day, if an acknowledgement of paternity exists, you find out just after that deadline, there's nothing you can do.
Counsel,
what is the purpose of the statute as you read it, 812?
I believe the statute is I believe it's based off of 42 U.S.C. 666, which is really about child support and ensuring that the state doesn't have to, pay for children if they're parents don't want to pay for them. And so I think it's to avoid disestablishments of paternity. And I think the case law under the federal statute shows that. Versus here, we have the competing presumptions of paternity. And I think that's a different question than simply disestablishing a legal father coming in and saying, I want nothing to do with this child anymore because we're not biologically related.
So despite the limitations that are set forth in E2 of 812, limiting temporally, expressly, and then by incorporation of Rule 85, we are to read from a subpart of Rule 85 that there is an exception to this statute which would permit effectively every circumstance in which someone would challenge this paternity finding, the voluntary acknowledgement, that allows a challenge at any time in the only circumstance that anyone's ever likely to challenge the voluntary acknowledgement of paternity. Doesn't it vitiate the entire function of this statute?
I don't believe so, Your Honor. And if you look to the actual language of 812E, it actually states that you may challenge a voluntary acknowledgement in this state at any time after the 60-day period. And the dissent in Andrew R. actually stated that it believed the plain language of the statute showed an intent by the legislature to come away from that time limitation imposed by, at the time, Rule 60C, now Rule 85.
Counsel, but due process requires diligence on the part of your client. You would agree with that?
Yes, Your Honor.
And isn't he on notice that he could potentially be a father from the beginning, from the fact that he did have intercourse with this woman?
I don't believe so, Your Honor, because based on what the OBGYN told mother here, she did not believe there was any chance that Mr. Strang was the child's father, and she told him that, and that was the testimony presented at the hearing.
I know that this isn't a putative father scenario, but that doesn't carry the day under 8106. I mean, you have relations, sexual relations like that. You're presumed to believe that you created a life, and you have to go down and register. Why? I understand we're not in an adoption situation, but why doesn't that logic carry over to this circumstance?
I don't believe it does, Your Honor. Adoptions are a different creature. I believe there's a different level of finality.
Again, I understand that, but tell me why it should be different.
In adoptions, I think another family is coming in and saying, we're going to adopt this child, we're going to be the parents.
Well, in this circumstance, Mr. Hernandez is saying, I'm the father. It seems to be quite analogous to me.
And I guess maybe I'm not understanding your question, Your Honor.
I'm having trouble parsing out the difference between the putative father logic and the fact that your client, who seemed to argue with mother about the fact that he was the father, didn't take an action, as Justice Cruz said, immediately thereafter. Waited some 3 years after the child was born, before he filed the petition to establish.
I think here mother told him repeatedly that he was not the father. There was no chance. It was definitely Hernandez. And so when someone's telling you, hey, my doctor says there's no chance that, when we had relations, you're the father, then he has no idea that the acknowledgement was signed. Once he found out he was the father, he did take action.
But Counsel, you just said that there's this repeated conversation happening. So obviously he was not satisfied, or at least doubtful, after the first time that he's told, you are not the biological father of this child. So there's sort of this cloud, this constant question. And so does he really have to wait until there's some AOP signed, or could he not have taken action and said, I'm taking you to court. I need to know if this is my child?
I think best practice I think all these cases prove best practice would be to get a paternity test. But I think these cases also show that best practice isn't followed. And here, once the OBGYN said, hey, this is when your due date is, and mom said, you're not the father, Hernandez is the father, my client said, okay, I'm not the dad. And then once he learned years later he was the dad, he did take steps. And I apologize, I do want to give mother's counsel some time.
Oh, 47 seconds. You quick. Yeah.
And
Thank
meeting
you,
just
Your
say
Honor.
ditto.
Yeah.
May it please the court, my name is Stanley David Murray, and I'm the attorney for the respondent, Caitlin Malay. In the 47 seconds that I have, rather than address the due process argument, I'd like to address how the Brumman court case got it correct as far as interpretation of ARS 25-812E applies. When you look at 812E, you notice it doesn't have any 6-month time limit because it incorporates Rule 85. The courts have interpreted that basis of challenging an acknowledgement of paternity on the basis of mistake, duress, or fraud as applying a 6-month limitation under a different section of Rule 85. 85C is the one that says you only have 6 months. And so the courts look to a different section of Rule 85 and determining a 6-month period that applies. But then the case came up with, well, what if there's a fraud in the court? Nothing in the statute says anything about fraud on the court as being an exception to the time limits. And so what did the courts do? They looked again to Rule 85, in this case 85D. 85D3 is the one that says these time limits don't apply, the rules don't apply when it comes to a fraud on the court. So if you can prove a fraud on the court, you sidestep these time limitations. So what did the Brumman court case do? They looked at another exception under Rule 85D, 85D1, which says you can file an independent legal action to challenge the acknowledgement.
Mr. Murray, I've let you go quite a bit over your time, so.
That's all I have to say,
That's
Your
all?
Honor, unless you have any questions. Thank you very much.
Thank you. We kept you quite active though, so you could put 1 more minute on for rebuttal, then you could have it for a minute extra for you all as well. So please proceed.
Good morning. My name is Allison Briggs. I'm accompanied by Brendan Murray, who's co-counsel in this matter. May it please the court, I would like to present my client's position. I represent Christian Hernandez, who, for our purposes, at least on our side, is the father of this child, Chanel. I would like to provide a little more background information to the court about some of the evidence that was presented at the trial court level. I had the privilege of being counsel at that level. And a few things that were highlighted by the justices, I want to provide some additional information to provide clarity. The first issue that Mr. Hernandez focused on in his presentation of evidence at this particular evidentiary hearing was that 9-month time frame between the first paternity test in November of 2023 and then the filing of the intervention pleading.
Does the record reflect when Mr. Strang learned of the acknowledgement of paternity?
Specifically of the acknowledgement of paternity, no, Your Honor, but the record does reflect several instances when Ms. Malay was pregnant that Mr. Strange learned or had information that he could have been the father of the child. Specifically, there was a witness that testified for Mr. Hernandez, Mr. Hernandez's former mother-in-law, who he considers to be his mother.
Is there a I know you should really move quickly, but is there a statute of limitations saying you must file an action for paternity within a certain time? I didn't see one.
There wasn't, Your Honor, but our position was similar to the arguments that were presented under Title VIII, which I know in the briefing was not, I kept bringing up Title VIII and the putative father registry, and I don't think that was what everybody wanted me to do, but that was sort of the direction we were taking, is Mr. Strange obviously knew. There was testimony provided not only by Mr. Strange and Ms. Malay that they knew that this was a possibility. And I also want to call out the issue regarding the OBGYN. There was testimony provided from a witness that was present at those OBGYN appointments that presented, at least her position was that the ultrasound technician was asked to alter the date on the ultrasound to make it appear that Mr. Strange could not have been the biological father.
Just kind of going back though to kind of the point that I was trying to get to with the timing that you brought up. What was it that gave notice to Mr. Strang that he had 6 months to file a motion?
I couldn't speak for Mr. Strange specifically letting him know that he had 6 months, but what was presented was that obviously there were attorneys involved. When the paternity test in November of 2023 was taken, and then when the second paternity test was taken, I mean, by the admissions of the parties here today, Mother and Mr. Strange were in discussion. I would assume he had access to counsel. I would assume he has counsel present today. I would assume that he had the ability to look and see how much time he had. The problem I think that we have is that it is a constitutional right to parent your child. You don't get to parent out of convenience. You don't get to parent when it is convenient. And when asked about that timeline on cross-examination at the trial court level, Mr. Strange's answer was, well, we took the paternity test in November of 2023 and then the holidays hit. So we had other things going on.
Well, we are, it may be that you are advocating for a fact-bound determination as to whether the acknowledgement of paternity controls in a particular case. But the question that we have to decide is the broader question, regardless of the record, whether a process that does not require notice can bind a person who does have rights. Secrecy and notice are very, very different things. And if we operate exclusively within ARS 25-812E and Rule 85C, it seems to me that it pretty much eviscerates the Section 803 independent paternity action. And these are legal questions that are going to affect people whether there were conversations going on or not. So what is your legal position with regard to, is there a due process hole if we put all of these situations exclusively within the 812E context?
In my opinion, from my client's position, I think the only way there isn't a due process hole is if you do that, is if you put things together under this specific timeline and hold parties to the laws and the statutes that are already available. I understand that Mr. Strang is not law trained, but the laws do exist. There's multiple laws with multiple timelines that exist for a reason. And my concern would be from a public policy perspective, which I think is the overarching reason that the law exists, is to protect the public and to ensure order. The other side of this coin is dangerous. If we allow this type of action to come in, which is essentially parenting when one feels like it, what really is stopping Mr. Strange or someone similarly situated from coming back when the child's 17 and a half years old and somebody like Mr. Hernandez has been providing support, paying child support, what have you? What stops him then from coming and saying, actually, I'm the biological father, I'd like to intervene now?
Well, counsel, a couple of things to that is, obviously, I think as we've discussed earlier, you may have a laches argument at that point.
Right.
And you go 17 years, there may be a lot of other facts involved. Two concerns that I have here, and one is, I wouldn't get so upset with Strang and some of the things he may have said when I look at the petition. Hernandez claimed to be the natural father when he had a paternity test that almost 2 years earlier conclusively established that he was not, and yet he put that in his petition. So I would be careful about casting aspersions at Mr. Strang. Secondly, when I look at the federal law that Roger S. discussed in finding that 812E is the conclusive or only way to proceed, it does require in there that when it comes to standing of putative fathers, the procedures, and I'm quoting, procedures ensuring that the putative father has a reasonable opportunity to initiate a paternity action. So this sort of dovetails with the question that Justice Bullock asked. Is it your position that as 812E in conjunction with Rule 85C, as it's set up right now, that that's a reasonable opportunity for a putative father to initiate a paternity action?
Yes, I believe that he did have a reasonable opportunity to initiate an action, just as any other person could go down to the Superior Court and initiate an action when they have.
Okay, so
yeah.
Can you give me the facts that support that this was a reasonable opportunity for Mr. Strang to have initiated a paternity action?
When Mr. Strange first found out in November of 2023 that he was definitively the biological, even if
that's almost 2 years after the acknowledgement of paternity, though.
Right, it is almost 2 years after, but I'm trying to view the facts in the light most favorable to Mr. Strange. My client's position would be that when there was an altercation outside someone's home when Miss Malay was pregnant and the discussion was held there of we need to tell Christian I might be the father, I believe that he had a reasonable opportunity to file something with the court upon the birth of the child. And that this...
So I'm sorry.
Sure.
So you're saying that because of at least ostensibly looking at that particular interaction, he had some level of reasonable belief that he was the father.
Yes, Your Honor.
Predating the birth, that he then, right after the birth, could have filed his petition for determining parentage.
Absolutely. I don't think the acknowledgement of paternity that the other part of this that I think is paramount, is incredibly important, is the fact that a lot of the cases that we're relying on to discuss this as part of fraud upon the court, both parties were aware. Mr. Hernandez was not aware when he signed the acknowledgement of paternity. This was the fact that was concealed from him. He did not know that there was a possibility that this child was not his. So it was fraud upon the court maybe by one party, but not by Mr. Hernandez. And I think a lot of the cases that we're relying on are very different situations. There's situations wherein it's, specifically we're trying to facilitate an adoption. So we have the prospective adoptive father sign the acknowledgement of paternity. That wasn't the situation here. Mr. Hernandez was essentially kept in the dark. So the people that had more knowledge in the situation and could have taken more action in the situation were Mr. Strange and Ms. Malay, not Mr. Hernandez.
I have a question. You mentioned Section 8106-01E, and I understand that this does not pertain to this proceeding, but our legislature has codified in law with respect to a putative father's due process rights that they can be waived. Lack of knowledge of the pregnancy is not an acceptable reason for failure to file. The fact that the putative father had sexual intercourse with the mother is deemed to be on notice to the putative father of the pregnancy. Is this relevant to us in terms of assessing what the due process rights of Mr. Strang and others like him possess in this context? And unlike a hypothetical where a man has sexual intercourse with a woman, creates a pregnancy, he actually knew that she was pregnant and believed to some extent that he was the father. So I understand why the due process implications may be diminished here, but to go to Justice Pollock's concern, the broader context, the broader application of this statute, what relevance does Section 8106-01E have in terms of the legal landscape about males, putative fathers, potential fathers being placed on notice when they have sexual intercourse with a woman that they may have created a pregnancy, and it's incumbent upon them to follow up?
My client's position at the trial court level, Your Honor, was that that statute absolutely needed to be considered and was relevant here. Because, and I understand, and that was something that we had, that was addressed. I understand Title VIII is different. I understand, as counsel said, adoptions are different. But if you boil it down to the basis of it, the public policy, which is to protect children and to look for permanency, my client's position is that 8106-01E absolutely applies in this situation. There was notice and there was no action taken. So our position is, in looking at the timeline, constructive notice was given when the pregnancy occurred. And this information about the OBGYN, I mean, unfortunately, we all know that there are so many things that happen. Children can be born early, they can be born preterm. We believe it is absolutely relevant, and that's why we continue to bring up that particular statute and continue to lean on Title VIII in this situation. Because
Counsel, I have a question about if this is akin to a termination, shouldn't due process require that a person who's going to, and generally speaking, I understand that your position is that your client did not know at the time of filing the AOP or signing the AOP, but shouldn't due process require that a person who's going to sign an AOP and knows that they are not the biological parent give some sort of notice, whether it be publication or some sort of notice to the world?
I think if the person knows that they're not the biological father, yes, I would agree with you, Your Honor. That's not the situation here.
Would there be any responsibility then, following that same logic, when the person has signed an acknowledgement of paternity and they later learn that they are not the biological parent?
I think at that point, we have to consider the best interest of the child. I certainly understand the public policy implication of that, but I think at that point, it depends on, I mean, if it's months, perhaps, but in this situation, this child has been raised by this man. I mean, I think at that point, her best interest and the overarching policies that we have and cases that we have that support the family unit and explore and, hold permanency very important should prevail. I think if both parties are aware, well, first of all, if someone's signing an acknowledgement of paternity and they're not the father, or they're not the biological father of the child, and they have that knowledge, I think that's another issue, of fraud. I think that's a separate animal, so to speak. But I don't think if someone has signed an acknowledgement of paternity and finds out years later, after they've been raising this child, providing care for this child.
What if they find out shortly after signing?
Shortly after, I would agree with the statutes that it should be the 30 days or a short time period.
That they should give some notice?
That they should, I know in termination, you have to, obviously, if you're going to do a termination, you don't know who the father is or the parent is, you have to do a putative father registry search. I think in that situation, it almost would be akin to a putative father, putting yourself on the putative father registry. If you're on, at that point, if you're on the acknowledgement of paternity, under our statutes, you're still the legal father of the child. So I think that would be the issue we would have to deal with there, is once the acknowledgement of paternity is signed, if no one else is stepping up and you're the only one, I feel like that could potentially damage the child. I hate to quote one of the cases that's a little bit older, but that would essentially bastardize the child at that point.
Right, but my question is, if you're talking about what the putative father might do, but my question is, what responsibility, if any, should there be on a person who does sign the AOP and shortly after finds out that they are not a biological parent? Can they just say, well, I sit here as the parent until someone who has no notice challenges me?
I think if they didn't, the distinction for me in my mind, Your Honor, is whether they knew at the time of signing. I think if they find out shortly after, and it's beyond the 30 days, beyond the 90 days, beyond the timelines that are already prescribed, and at that point, I think the permanency statutes and the permanency principles would prevail, and they're raising that child. I think at that point, they don't necessarily have an obligation to anyone other than the child. Would be my client's position.
Ms. Briggs, may I ask you, I have two questions regarding Rule 85 and just how this all fits together.
Yes.
I confess I've struggled a little bit with Rule 85 because it's odd to me. This is my first question, is just a comment. It's odd that it fits at all in this scenario because Mr. Strang was not a party to the acknowledgement. And Rule 85B, just like Rule 60B, talks about the court may relieve a party or a legal representative from the impact of the judgment. Is it undisputed, I suppose, legally, that a non-party to the family court matter, or I guess in this scenario, the acknowledgement, has the ability to file a motion under Rule 85? I know the Court of Appeals has said that, but that was kind of my threshold concern.
I don't think it's undisputed. I think from our position, what we felt would have been procedurally appropriate would have been for Mr. Strange to file his own FC and then for the cases to have been joined. I don't think that the application of Rule 85 was essentially what the court had at its disposal to address the issue, which is why we filed a motion to dismiss, and to dismiss the intervener, and essentially said, the intervener is not appropriate here. My view of the intervention statutes or those statutes is more of a third-party rights situation when there's already an established relationship with a child, when it's a grandparent or a caregiver. I think that's what the statute calls out. So I don't know that Rule 85 necessarily, I think it's the best fit. Yeah. It's an odd, you see what I mean? It's an odd fit because he wasn't really a party to it. But the second then a question has to do with as you, if you're going under Rule 85, as you said, mistake. There was no mistake here. Your client is not mistaken in
in doing the acknowledgement, he thought he was the father. There is no mistake, there's no fraud, there's none of that. But I'm wondering about B5, if applying the judgment prospectively is no longer equitable. Could that be a scenario in which, when you have a very unfortunate situation, frankly, like this, that we can leave to the equities of the court to make that decision? And if that's so, it simply has to be filed within a reasonable time. And I'm wondering, what's your reaction to that? Wouldn't that solve some of the notice problems and allow the court to then look at the particular facts of the case and make the decision at that point?
I think that situation is exactly what should be applied in the situation, and I believe that that's what Judge Kushner did when he had the opportunity to observe the credibility of the parties, take in all of the information. I think he did allow, under 25-814, weightier logic and policy to control in that situation. He was in a unique situation where he observed the credibility and the demeanor of all parties present and assessed what's best for this child. I think that was the unfortunate position that he found himself in, and that's what he did. So I would agree that is where we need to lean, and I believe that that's what happened here.
But the point I'm more making, rather than the outcome here, is that there would be no 6-month time frame in that scenario, because that only applies to B123. It just has to be reasonable time.
In that situation, Your Honor, I think even if there isn't a 6-month timeline, I think everybody has the same question about why waiting. Once you had that paternity test in November of 2023, why wait? I think we all have the same question. And that was a question that was asked at the trial.
I would dispute. There may have been testimony on all of those things, which is great, but the judge made his determination as a matter of law. And so I do not see those kinds of evidentiary findings where we defer to the court as having been made here. And I think that's exactly what your opponents are asking for, is an opportunity to get through the weighing of the presumptions, equitable defenses, and that sort of thing. So didn't this ruling short circuit the very process, the best interests and all of that? Doesn't this really short circuit the ability of the parties to present their relative positions?
In my opinion, no, Your Honor, because I think the opportunity was there to present what your goal was in all of this action, what the goal should have been, obviously for the child. I don't think that this hearing and the process that we went through in the trial court does short circuit anybody's ability to present evidence. In fact, I think the parties were given more than an opportunity. I mean, this was set for written briefing, it was set for oral argument, it was set for evidentiary hearing. The process was quite lengthy. And I think ultimately what we were left with is what's best for this child that's known this person as their father. And then I don't mean to cast aspersions, that's not my intention, but it does appear that the period of inaction from Mr. Strange and Ms. Malay, because they knew the period of inaction is almost being rewarded, and who suffers? The child. I don't think it was overlooking those things. I think due process was more than provided to all parties. I'm sure Mr. Hernandez wishes this was over. I'm sure he wishes he could move on with his life and just continue to parent the child. But I think that this issue was properly presented to the trial court, and the proper ruling was found.
Thank you, Ms.
Thank you.
Okay, 1 minute. Thank you for rebuttal.
Thank you, Your Honors. I want to be clear, the trial court here did not do an analysis under 25-814C. The trial court found that Mr. Strang's action was time-barred under the language in 25-812E. And I want to point the court to the Brummond ruling in paragraph 17, where the court found that applying 25-812E to biological fathers' paternity actions would permit their constitutional interest in forming relationships with their children to be erased without any notice or opportunity to be heard, contrary to public policy. We're asking the court to make that same holding today and allow Mr. Strang to move forward to that 814C analysis so that the court can consider the best interests of the child rather than imposing the time limitation that it did in this case. Unless the court has any other questions.
Did you ask for relief under Rule 85B? Is it B5? The equitable, the prospective equities provision that I cited?
I believe the motion asked for relief under 85B generally. It did not specify.
Thank you.
Thank you, Your Honors.
Okay, thanks for all counsel for your argument today and your briefing on this matter. We realize the seriousness of this matter and the interest at stake, so we will give this all due consideration and issue a ruling in due course. And so we will remain on the bench and allow the next case to come forward, the attorney. Thank you.